All right, I'd like to, I don't have anything good to call this meeting to order. Oh, thank you. Jeez, yeah. I'd like to call this meeting of the East Lyme Planning Commission to order. It looks like we are without Chairman Brian Bomback for now, so I will sit in as chair. We do have Secretary Tim Leducer here, and we do appear that we are going to be sitting alternate Kevin Mills for the meeting. We also have Rich Gordon. I don't know if we actually need to go down through now that I've said everyone, but I suppose we can, just for price. So I'm just going to have everyone just roll call. Nick Menepace.
Kevin Mills.
Rich Gordon. Tim Leducer.
All right, let's get started with the Pledge of Allegiance then. All right, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. I believe we have a rather short agenda, and I don't believe that we are going to be reading in the minutes from the previous meeting, as this is a special meeting. So we are just going to jump right into old business, subdivision regulations, section 4 and 7, application submission procedure and open space and easement.
So I'll hand it to Tim Bleezer, our town attorney. He and I have been going back and forth regarding the regulations. We started this somewhat of a previous commission. It was a different mix-up, but nonetheless, we started down the road. We deleted the ERT requirement in the regulations in an effort to replace it with some new language. We sent that to the town attorney for review, and I've invited him here tonight to explain he has a number of comments regarding those changes or proposed changes. So I thought you should hear from him first, and maybe we can figure out the path forward from there. So, thank you.
If I sit right here.
I just figured it'd be easier tonight because I have so many papers to be able to have the table. My name is Tim Bleasdale. I'm from the Town Attorney's Office, Carmody, Torrance, Sandick, and Hennessy. And I guess where I'd like to... Oh,
Sorry, I'm trying to adjust the camera.
oh, sorry. Oh, wait.
Board of Selectmen get their own. Oh, my.
Okay, basically.
Yeah, you gotta be careful.
You can slide this to you.
Yeah. Thank you. Sorry, folks at home.
Oh, get a nice shot of our new recording secretary.
Should. Ah,
There we go.
there we go.
So I'll kind of pick up on a comment that Gary made, that this project was sort of started by an earlier formulation of your commission. And I don't know, and I apologize for not knowing this ahead of time, but were many of you on the commission in 2023?
I was.
You were. Yeah,
Yeah,
okay.
we were all.
I thought,
3 or 4.
3 or 4. That's what I
All
thought. There's a
except
couple,
Mr. Mills
right?
were part of the commission
Okay.
at that time.
So, so I guess at least for Mr. Mills' benefit, I'll give you a little bit of background if that's all right. So, the 2016 version of our subdivision regulations had a requirement in it that said if a subdivision had 20 lots or more, so certain sizes of subdivisions, they were required to undergo an evaluation by an environmental review team. So we had a subdivision that was approved here without that evaluation happening, and essentially the reason for it, there was some, in the court record at least, there was some mixed evidence about why exactly the evaluation didn't happen. Either there wasn't enough time for the team to perform it once the referral was made, or they just had stopped doing it. The notes that we had in our file at the firm said that they reported to us that they had stopped doing them in 2013. So either way, we had a regulation that was basically impossible to comply with. And so in 2023, I believe it was, right? We started the process of removing this from our regulations and replacing it with something else. And so that's where we are now. So the ERT piece, the environmental review team, has been removed from your regulations, and you have now the environmental impact assessment that's in section 4-14-3. And proposed regulations that I'm here to talk about with you tonight were something that the commission was writing with Gary's assistance to sort of augment what is already on the books. Does that make sense? Does anyone have questions about that so far? No? Okay. So this draft and different versions of it have kind of gone back and forth between Gary's office and our office, and we've provided some comments. Most recently, we provided lengthy comments that look like this, except without the highlighting. Do you have those up there? So it's dated May 15, 2025. So I guess I want to be as helpful to you as I can. So I don't know if the commission has a preference for how we go through this. Do you want me to just kind of go section by section and talk about the comments? Or do you have questions after having looked at the comments?
Well, they're just seeing the comments
Yeah.
tonight, so.
Oh, this is the first time you've seen it?
Yeah.
Oh, okay, all right. Okay. Well, I'll start with sort of a global comment then. In looking through the draft and talking about this off and on over the last year with Gary, I've always sort of been struck by the fact that a lot of the information that is being gathered by these environmental impact assessments is information that applicants are already providing in under the requirements of other sections that you have. So, let's see. Where, I'm just looking for my I'm sorry, I seem to have misplaced one of my pages here. Oh, here it is. Got out of order there. So, in Section 4-2-3 of your regulations, there's a long list of other types of reports and things like that that applicants have to provide. And I think a lot of the information that is collected and resubmitted under the new regulations is also already submitted under that. And so what I would suggest for this commission is to think about whether you still want to move forward with this, or if you want to scale it back or kind of lean into the existing regulations, since it's already providing a lot of that information. But having said that, I'll go to the actual regulations themselves now. So in the draft that we received in January of last year, it begins with Section 2. And adding a definition for something called a significant effect. So our comment about that was that it looks like it's off to a good start, because we're going to define in our definitions what a significant effect is, but the definition itself is not complete here. And that sort of ties into some of the other kind of global comments that we had about the regulations in general. So if you go to it's section 4-14-2, 4-14-3, and 4-14-4. Each one of those goes on to have language that essentially redefines significant effect again. And so one of the comments that we had is that we have to be careful that we're consistent. So I think the best place to define what a significant effect is would be in that Section 2 definitions, because that's where people are going to look for a definition like that. And then in these other sections, you just need to make sure that the framework that you're setting out is consistent between that definition and the framework that you're putting in these other sections. Does that make sense? Mm-hmm. Yeah, okay. One of the issues that came up in the appeal was whether the commission had the authority, the legal authority, to waive the requirement of doing that ERT. And so I think the commission was trying to address that here in section 4-14-6, because we have the EISs where we have this new proposal tucks them both into section 4-2-3K, but then also then puts them in here. So the reason that's significant is in 4-2-3K, you have requirements that that the commission can waive, right? So if we list it here as something that can be waived, but then later listed as something that's required and we don't have that provision that it can be waived, it creates that question of inconsistency. And that was an issue that the court was specifically looking at back in the appeal in, what was that, 2022? I think was the initial appeal.
There was
The
an
Lepkowski one.
Yeah, because he applied, he withdrew. I think he applied in
Actually, I said
2017. He withdrew, reapplied, then it got appealed.
Yeah.
So
So-
I think it was
Yeah,
2022.
Yep. So 2022 was the
Yeah.
initial appeal. Yeah, and that was one of the issues that we were trying to address here. So if the commission wants to be able to waive the requirement for these EISs, you should have it be consistently stated that way throughout, is just our comment there. And I think the rest of the comments that we had in this draft are fairly self-explanatory, or there's no comment. Simply, like for instance, 4-2-3K is simply adding the EIS to the list of things that can be waived. There's no problem with that as long as it's consistent throughout. So little comments like that. I guess it's a little bit tricky since you're just seeing this, so you haven't had a chance to read it to come up with your questions and things like that. But I think one of the things that I was hoping to get out of our discussion tonight was to hear from the commission about what's your goal for these draft regulations? Like, what would you like to achieve with them? So that might help me in working with Gary to figure out how to help you get over the finish line.
Maybe I could answer that. I think the essence here was because the previous section required an ERT review, and if you look at what that encompasses, it's a pretty in-depth analysis of a piece of property. And I think the commission is wanting to get that same sort of review, whether it be from the applicant or in this case with the ERT. What was nice, it was a third-party kind of unbiased, here's factual report. And again, anything that the applicant brings forward, there is a bias to it. So that's, they're paying for those reports. Again, because of the issue of not being able to, get a report from a business or entity or agency that no longer performs them or is refusing to do them, provided, unless the municipality requests that ERT. I think we're looking for a means to have in the regulations some surety that we're going to get the information regarding the environmental aspects of the property, as well as the impact of the proposed development, so they can, I think, evaluate that correctly. It's now again, when you compare that to the statutes, I think the commission, in terms of reviewing a project and whether you deny it or not, on whether it meets your regulations. And I guess the question here is, you can provide a plan, but what if the plans, I was thinking about this, there's nothing here that says, well, what happens if, what's the threshold for the impact, where you're forced to deny something, or does it matter, right? Does the commission have the discretion to say, well, there's a nominal impact versus a significant impact, and like you had indicated, we define those things, so they're going to have some criteria to weigh that against in that regard. But I think that's what they want to be able to do, is to weigh the impact of a project on a particular piece of property as it relates to subdivisions. So I think they just want that surety that they're going to get the information that they're requesting.
I see. So
also, I mean, I certainly think, I understand, from my background, I understand what an environmental impact statement is, I understand what goes into it, and it's a thorough review. And certainly, I think anyone can make an assessment and decision based on the information in one, whether to proceed forward with the project. So I like if you look, your standard protocol for an environmental impact statement, I did provide you in your packet, there's a kind of just some notes as to what goes into one. And that's kind of like the ideal scenario. That's all the information that you'd want. And I think a lot of that is gleaned, and we could maybe just clean up our current regulations in various sections to ensure that we're getting what we're looking for. Nonetheless, I think the draft that I have put together, there is a draft in your packet that's got some red highlight dated May 13th, 2024. So it comes subsequent to this email, and where I think is where we last left the regulation, and you'll see it says add significant effect, and I gave it a definition, what it means, an adverse effect that has identified as significant based on the criteria. I didn't finish it. Shoot. So we'll have to come up with that criteria. And I think that's basically, I was trying to outline this to coincide with Tim's comments so that we can just fill it in if you want to continue forward. So in terms of section 4.2 in the reports that we currently require, we require a natural and cultural resource and site analysis plan. And that's to include a number of things from slope analysis to soils, floodplains, stratified drift aquifers, generalized types of vegetation. So versus, here maybe this is an opportunity to get a little more specific about the vegetation on a particular site. Landmark, asset trees, unique scenic features. Again, we also have a section here regarding requiring an archaeological survey. We also require applicants to submit information regarding the Natural Diversity Database, and if there's anything, endangered species in the vicinity. We also request a biological survey. Soil scientist report, pesticides, traffic report, and I don't know, these are saying these reports are submitted. It doesn't say by whom. Maybe that's the kicker, right? You've got to get the professional, because any engineer or land surveyor can put the report together, or even a planner. But if I'm not a traffic engineer, or if I'm not a soil scientist, I shouldn't be putting that report together, type of a thing. Biological survey, well, again, lots of land surveyors and engineers put these surveys together and say, here's the biological report. I think the last few subdivisions that we've looked at, granted they've been small, if you look at the design report that's been submitted, it goes through this chronologically, just boom, boom, boom. This is how we address this report. This is how we've addressed this. To me, it answers the question, but the next question I have is, well, who conducted that survey? Who conducted? And sometimes we don't have that information. So maybe we clean this up and say we need a specific biologist to weigh in on it. I don't know.
Somebody with certain credentials, you mean?
Correct.
Yeah.
Yeah, I'm more for reviewing and refining 4-2, honestly, than I'd rather clear the waters out and not bloat this document up unnecessarily, But
I'd be in agreement on that.
Yeah.
I know that, I know some of the planning for 2023, I think Rich may have been the only actual sitting member at that time. And I know that 2023 is when I got elected, so I can't say I was really part of this conversation, at least for all of it. But that would seem to me to be the easiest way to deal with this, is to try and make this a little bit easier to understand. That is what our esteemed secretary is also saying.
yeah, I mean, adding the language in there to specify where these reviews are coming from, like Gary was saying, I think is important, because, yeah, anybody could put a report together and sign it and say, here you go. It has to be from an accredited source. I think adding that language in there. Because it looks like with adding, the EIA requirements on there, it's just adding too much confusion. Like,
I think to the extent this is helpful to hear, that's in line with more or less the original recommendation from the town attorney's office when we were dealing with this issue in the court, was that initially your regulations at that time, that section 4-14, it essentially had 3 different agency reviews, and the third of those was the ERT. And so what we had recommended at that time was to simply just delete that third piece and keep everything else the way it was. So what you're talking about there is similar to that idea, but it certainly augments everything by adding those credentials into 4-2.
yeah, because it's almost like we have some contradictory language in there, contradictory to 4-2. What do you think, Rich?
I kind of like the way Gary had it set up, like a more, I guess, more of a guidance, and we have to look at every specific subdivision application, see, we're not going to, look at everything that's in the, that Gary put in here in the 4-14 section, but I guess we want the flexibility to, whatever the situation is on a specific subdivision application, but
So we may be able to address that by, in 4-2, just adding a component. So the last one is J, an open space report. So right after that, add another section that says, and such other information as the commission may deem necessary.
right.
And that gives you that leeway.
We have 4.2-15, other data and information may be required from the applicant in order to establish that the proposed subdivision complies with the requirements of these regulations. Is that sufficient, or do we need to be a little more elaborate?
That sounds, where was that?
4-2-15 in the current regulations.
Oh, I see, 4-2 dash. Yeah, that sounds like it covers what we're trying to hit there. So
Falls under
yeah.
that list of reports. They have a construction
I
sequence,
see.
state highway, utility permits and agreements.
It's at the very end of 4-2. Okay, yeah, that's exactly what I was talking about. Yeah. that's
So would we
perfect.
need to add anything additional?
No, I don't think so, because it's right there in 4-2 already.
Okay.
So really then, it looks like the direction maybe the commission's going is just adding, those credentials in there.
Credentials, and then this subsection K, because if you,
Subsection K. Oh, right, yes. Right, because that's in the proposed.
right, and
Yeah.
I'm looking at in the current regulations. So we got the initial, you need to do an evaluation. Yeah.
In the original subdivision regulations said shall, now it's kind of giving us more flexibility, that may, if this, depending on what we're looking for in a specific subdivision application, we can.
Yeah, and so there is this requirement here for this assessment, that they be a detailed description detailed statement setting forth the description of the proposed project, environmental consequences, adverse environmental effects, alternatives, and that is.
I remember that meeting. It was a,
And again, there's a little bit of subjectivity here, but if we define that this only would apply to subdivisions where the land to be subdivided consists of environmentally sensitive resources, such as but not limited to wetlands, steep slopes, greater than 25%, water courses, flood hazard areas, ridge lines, endangered or species of special concern. So parcels of land outside of that, not having any of those things on it, would not necessarily be subject to this. Just understand that that's kind of the case now. I don't know if we've had any applicants kind of push that, but,
Yeah, I remember that was the original, there was only one company in the state, right, that was doing the ERTs. And they shut down.
yeah, the
This
Connecticut ERT had King's Mark did the western half, and then it was the Eastern Connecticut ERT did the eastern half, like just from the Connecticut River, right? Split it. But they've then, as you've heard Tim, they since stopped doing ERTs. I think, I'm not exactly sure why, what their role is. And that they do them, they've made it clear, it's gonna be on property that's not subject to a subdivision, and the request comes through from a municipality. Okay, so,
They were really necessary, when they were active, they weren't necessarily responding within the 30 days, so that kind of gave us, theorized that it was okay, that it was okay to waive it at that point.
And I think in addition to not being able to meet that 30 days, I think they told us on the Lepkowski case that it takes about 3 months for them to do the review. So it'd basically be impossible for them ever to meet that 30-day window.
I think the real intent behind the ERT was to evaluate property that was going to be preserved as open space. So they would do this work for the municipality who's preparing the grant that submit to DEP for the open space and watershed acquisition. And that's a great report to submit with your application for grant money for open space. You know, very thorough. So I think that was their original intent, whatever set up. But so I guess looking at the current section, I mean, we can continue to modify what's been approved. We can, you know, I guess the question here is, to you, Tim, is should we further edit what we've got? Maybe making a couple of minor changes to or is what we have sufficient, or is it, you know, I guess.
And we have to remove that language, right, with significant
I think
effect.
I think so. I mean, we do have, it defines it here, so either we gotta put it in the definitions. It's defined in 4-14-2.
Right. So I guess it's sort of a tricky answer here because I'm not the policymaker. You folks are. So what our comment is about defining significant effect or anything along those lines is that just however you decide is the right way to define it for your regulations to achieve the goals that you want to achieve. We just want to make sure that it's consistent throughout. So if we add it into that section 2, which is what the initial proposal appeared to be, that we were going to write something that goes in there, that's a perfectly fine way to do it. It's a great way to do it, just as long as it's consistent with, you know, however else you use that term later on in your regulations.
Could you just like reference, once you define it once, can you just reference it and say, as set forth in section 2? That way then each time you go back to section 2,
The right.
instead of trying to redefine it?
Yes, exactly. And generally speaking, so section 2 contains the definitions. So once we define a term there, it applies throughout the rest of it.
Correct, okay.
So yes, we don't have to then redefine it. We just rely on the definition as you know, cited in that section 2.
I mean, essentially, if all of section 4-14-2 is the definition. So basically, that just belongs in a different section.
Yeah, that would need to be in the beginning of the document.
That's easy enough to do.
So, in regard to 14.4, 14-7, that last comment on your page 3 indicated that you believe that might be a typo. I'm going to suggest that it's not a typo. I was trying to kind of mimic the state statute on 8-3 referrals from zoning, where if the planning commission doesn't act, it's considered favorable.
I'm sorry, it's considered what?
If the planning commission doesn't act on an 8-3 referral, it would be considered favorable.
Okay.
And the zoning commission would then be able to vote. So I always recommend the planning commission take action if they find it inconsistent with the POCD, because that requires zoning then to have a two-thirds vote to pass, which they need anyway.
I see.
Anything. So I think it wasn't, so the question here is, I mean, not saying anything should, I mean, maybe we should edit that, maybe we shouldn't, you know, if we did fail to, I think the idea is that if the Conservation Commission doesn't report back and we don't have it, we can continue to move forward with the application.
Right.
That's-
Yeah, no, that makes sense.
So, in terms of this, you had recommended we just merge 14.5, 6, and 7. I mean, we can just make that one regulation, call it 14.5, and one big paragraph.
Yeah, I think it made a little bit more sense to me, looking at it like that, yeah.
Okay. So I think there are just some really minor changes that we need to make to the section, and it's not really that massive of an overhaul as I was thinking it would have been.
Really just sounds like we need to clear it up a little bit more.
I think so, yeah.
Yeah, that was our global comment, was just to make sure it's consistent and everything matches up.
Right.
I would note, you know, for those parcels of land that don't meet that definition of, you know, sensitive, environmentally sensitive resources, you know, having all of those features, you still request a biological report, you still require all of that in the other section, so we should be getting that for the most part.
Right.
I think an environmental impact statement is just a better organized document with all that material in one place.
Right.
But it's neither here nor there. I think at the time, the commission just felt that it was, you know, kind of covering them in lieu of omitting the ERT requirement. This was something to put in place that kind of fulfilled that need. So, what I think based on this conversation, I'm a little more clear as to what we need to do, and if the commission wants, I'll go ahead and make the changes to the draft, and I can provide that to the commission at the next meeting. We can have a discussion amongst everyone.
Right.
Hopefully by then, the members who aren't here tonight will catch the YouTube video, and we can have some nice spirited conversation and figure out the best way to move forward.
Thank you.
Which I think is just really cleaning it up. That's our definitions in particular. If I'm correct there.
Sounds good.
Do we need to make a motion to task you that, Mr. Gage?
No, you can if you'd like, but you can say
I
please.
don't think we will just waste some time doing
Practice
that.
it.
I
Making
think
motions.
for the record, Avi, you could just note that the commission's directed me to make the changes to the.
Yeah. So noted.
So just to recap, so we're going to add language to 4-2 to specify that these inspections, these reports need to come from an accredited source, as well as bolster, 4-2, the existing requirements. Adding a definition to section 2 for the term significant effect. And that would mean we're eliminating the requirement for the EIS entirely, or are we sticking with that? So I see a recommendation in comment here, whether we want to consider whether an EIA is necessary in the light of 4-2-3. Because since we're already requiring these things, right?
Correct.
Okay.
That was my comment.
Okay.
I guess from my perspective, especially if you're adding into that 4-2, these requirements that these different various reports that the applicants are, getting those from accredited individuals who have the expertise to actually be opining on those things, then, maybe you don't need it. But, again, that's a policy choice for the commission to make. I'm sure Gary can give you some more technical advice on that from his perspective too.
I'm just trying to think of the most comprehensive way, the easiest way to craft this, so that you're basically saying, if you're going to furnish a report, it ought to be accredited with by whom, right? Like what professional prepared it? Understanding that just general project narratives can be prepared by anyone. Well, that's fine. Let the landowner, if they're not a professional.
We're at the discretion of the commission.
There is that as well. I mean, I know under inland wetland regulations, while the statutes are pretty clear that soil scientists are the only ones who can delineate wetlands, you can have other individuals who are qualified to delineate those wetlands, and the agency can accept it. They have to agree. And I would just point to Gateway as a good example of where we had their environmental professional, Scott Rebedew, was not a certified soil scientist, but he was accredited. He had the background, the resume, the CV to back all of that up, and the commission agreed to accept that. So I think if we have some sort of level of, measurement there, like what's your credential, just provide the credentials. I think that you could rest easier knowing, okay, someone who knows what they're talking about prepared this thing. It's versus just maybe Joe homeowner, it's
Scribbling it down on
scribbling it, yeah.
a piece of note paper and signing it.
I think it also might help distinguish between, whether it's the professional preparing or making a statement versus the non-professional, say, landowner, right? Who's speaking. I'm just thinking out, in my head of other applications in the past where I don't know it was necessarily clear who was representing who, so I think this kind of might help with that as well. So if there's no other questions, I'm just going to add those couple of things and clarify. I guess with the accredited sources, do we want to specify like the specific expert? Is that the recommendation? We would identify.
Yeah, where there's a profession that a license exists.
Identify the licensing.
Yeah, identify the license. If there's not a license, some other kind of.
It had to be a criteria.
Yeah, like by education or something. I think the important thing to keep in mind is Gary's going to brainstorm some of this stuff for you guys, and you'll have a chance to look at it. So you can give him feedback if you want to make adjustments.
I'm wondering if I could just take from like the wetland statute, that portion that talks about here if you have another professional,
Right.
and kind of mimic that to fit that.
Yeah, that's a good idea.
And we're also required to have a public hearing on this.
Is that in? I don't.
No,
Didn't see that.
no, for
the
any changes in the subdivision
changes.
regulations.
Oh, yes.
Yeah,
Yeah,
yes.
when we get there, when we're ready to actually get the draft all
Right.
fixed and corrected, we have to notice properly in the paper for public hearing.
Make sure that the commission's happy with the language before we go
Right.
through those steps, right?
Are we operating any kind of time?
Only to
Limit
open,
here.
we have to follow the notice requirements to open the public hearing. Once it's open, because it's a commission-initiated application, we would have the discretion, the time to take as long as we want with that public hearing.
Okay.
I don't, I do recommend trying to follow the statutory timeframe. It keeps things moving and rolling forward. And, if you can't get through your own regulations, let's say change in a even, let's say at a maximum 90-day period, then maybe you should withdraw, start over, right? That type of a thing, because you've gotten so far from maybe what you started from. I mean, this is obviously small stuff, but
Well, in the process that we're in right now, we haven't done anything yet that would trigger that kind of
Right.
timeline or
Yeah.
anything like that.
Okay.
At some point, though, possible.
Well, I think I'm good.
All right.
yeah, I got the clarification I needed. I don't know if you have more to add, Tim?
Not really. I think, if the commission has more questions after looking at the comments we have and looking at the new draft that Gary does, I'm happy to address those.
Thank you.
Thank you.
Great.
And I saw on the agenda that you also wanted to discuss section 7 with the open space.
Yes, so this would be kind of a new topic, unrelated to section 4. So some of the concerns that regarding open space is who can accept the open space? And what we have nonprofits, section 7 here of our regulations, homeowners associations. So open space has to be dedicated either to the town, the state, the East Lyme Land Trust, homeowners associations, utilization of a conservation easement with or without public access, recreation easement, any combination of the above, private ownership with appropriate taking of development rights, ways to preserve it. So the question here is, there's been much discussion regarding the East Lyme Land Trust and their ability to accept land as parts of subdivision, which they can. I mean, they're a nonprofit and they qualify. I think some of the concern that I've heard is the way they operate as a business, and is that really in keeping with the spirit of protecting open space? I don't know. That's not my decision nor my place. What I do know is that they are an entity that is eligible to accept the open space. I think the question that's being brought forward is that the best entity to control it? If in situations where we've seen open space transferred to the land trust and then transferred to a developer and then back to the land trust, only to leave a portion of that land as developable, is kind of head scratching, even though that was the case. So I've seen cases where the land trust has acquired land. I believe there were lot line revisions conducted, and we create building lots. So to me, you have to question, what is that what you want for the entity accepting open space? I mean, I think the other issue we have is follow-up, maybe on the town side. Particularly in the past, there was little oversight as to what got filed on the land record with these subdivisions that were approved, and maybe that's why some open space was filed and some wasn't. I don't know. So trying to just address some of those issues that have been creeping up regarding open space that hasn't been conveyed, maybe is supposed to have been conveyed. With the land trust having developed land, as a means of protecting land, I mean, that's an interesting concept. I don't know if I guess that falls under the definition of the purposes of conservation. So when we can convey portions of land out for development in an effort to preserve the bulk of the land, maybe that's the interpretation. So, and to watch the land trust do that, it just seems ironic.
Lance, do we have the legal ability to say that we even, just bring that up, do we even have the ability to say that we don't want to convey land to certain areas because, like, certain nonprofits that would be eligible for land? This is a group that is, designed to conserve land. Do we even have the ability to say, no, we don't really want them to take ownership of some of this open space?
Sure. So your statutory authority here is fairly broad. Essentially, so this is 8-25 of the general statutes. Essentially, it just says that your regulation shall provide for this possibility, that there's open space and where it's gonna go, that sort of thing. Your regulations as written do specifically identify a particular land trust. So this is subsection C, but it also goes on to say, or other private organization. So under that regulation, it's not necessarily requiring that it go to a specific land trust. It could go to a different one. You're also not required by the statutory authority to specifically identify particular organizations that you do or don't want it to go to. So I guess in sort of our little area, I think we're a little bit unique in that we have specifically called out a land trust by name. To the east and west of us, the immediate towns on either side of us, they don't do that. I believe in the old Lyme version of this, the equivalent of this regulation, I believe it says something along the lines of, a nonprofit deemed appropriate by the commission. So that gives their commission the ability to look at the one that's being proposed and, give feedback about whether they think it's an appropriate organization to take, the easement or title to the open space. And I don't see any reason why under the statutory authorities that you couldn't revise your regulation to be something similar to that. And that would give you a little bit of discretion to actually vet whatever organization is being put forth as the title holder or easement holder for whatever land is being preserved.
Yeah, thank you.
So I think hearing that kind of answers my question, that you could edit East Lyme Land Trust to be nonprofit.
That would seem to be the easiest thing,
Yeah.
to just remove them specifically from the was there any other question about Section 7, or was it primarily that?
If I could just interject, I think in addition, if you're going to make that change, I wouldn't just remove East Lyme Land Trust. I'd also add that language about, that you
Forgive me,
deem
I was
appropriate, just to
terribly
give yourself
saying, yeah.
that discretion to kind of vet the organization if that's what the concern is.
Yeah, like the language of adding at the commission's discretion, I think that,
Yeah, agreed.
So what I can do is I can get those regulations I'm referring to you, and you can see the examples I'm talking about.
Yeah, that would be helpful.
Yeah.
731
Yes.
says an applicant proposes open space to the state of Connecticut, East Lyme Land Trust, or any other private organization. A letter from the authorized agent of that organization has to be provided. So we do require that. I think we've had a couple of applications kind of go through. That letter was never submitted.
Mhm.
The land did get conveyed to the land trust, but so no harm, no foul. But normally, this tells us that that organization understands it's coming to them. And I would just note that now that we have the Commission for the Conservation of Natural Resources, their charge under the statute is an inventory of all of the town's open space. So I would just comment to the commission and just say, note that, and then say, any open space that the town acquires through the process of subdivision or re-subdivision, we now have an agency that would help monitor that, and I guess in addition to, or Park and Rec, assuming it's not a public park, right? If you look at Darrow's Pond and the Darrow's 16 Mostaway Road, how that's functioning, it's all open space, didn't necessarily get acquired as a result of a subdivision, but between Natural Resources Commission and Park and Rec, we're keeping an eye on it, and the Friends of Oswegatchie Hills as well volunteered to provide that annual report. But I think that might be able to shift to our Conservation Commission to do that annual reporting to the Board of Selectmen. I'd have to just make sure that that's legal to do, but that would be my guess. So with that kind of idea, I would think that the commission might want to consider accepting the open space as town open space versus having it dedicated to some other entity moving forward. But then again, every circumstance is different, so.
This would be a similar, relatively minor change, it seems like, just a change around the framing, and then the wording, I suppose, with the new commission on natural resources for the town. Sorry, I'm not getting the name right.
It's a mouthful. We could have made it smaller.
Conservation of Natural Resources, I think.
The commission.
Yeah.
Board. Just call it the Conservation Commission, but
Sure.
it's the commission by ordinance. It's the Commission for the Conservation of Natural Resources.
Gary, is there a minimum amount of land that can be conveyed?
So per the regulations, the open space has to be comprised 50% upland to wetland and minimum starts at 10% under a conventional subdivision. Our CDD, or Conservation Development Design regulations, require 30% minimum to take advantage of the dimensional flexibility offered by them. And then if you provide additional open space above and beyond 30, you can benefit from density increase. And that's, kind of the incentive to try to provide more. The goal was to get larger, more meaningful tracts of open space land and cluster the housing.
Is there any land that's conveyed, say, wetlands, and then say that the developer wouldn't have to go in front of an inland wetland committee because now they're not developing on that land?
And this was brought up at the last Inland Wetland Agency meeting. I believe it was Don.
Femister.
No, he was on the commission, but Don from Against It Lake Association. What's his last name? Sun Harbor Management.
Al McKenzie?
Nope, not that. I think he's on Harbor. Could be on. Anyway, the Patagonia Lake Association.
I'm not sure if that would give it to you.
No,
No.
he was talking at large as.
Oh, I see.
It'll come to me. Anyway, they were, the Patagonia Lake Association was commenting on some of the concerns about the land trust acquiring land, and particularly as it relates to the Hathaway property, because it's on Lake Patagonia. So they had raised some questions, I guess, regarding the, lack of a better term, the process that was followed and how the land came to be acquired by the town, and how pieces got carved off and subdivided. So the questions they raised, I think, is what's really pushing this issue forward, and why I put it on this evening's agenda, in an effort to try to alleviate some of those concerns. I thought it would be worth the conversation as to how we kind of maybe navigate around some of this stuff. Their issue was with subdivisions where the wetlands were conveyed out of the land, either prior to the application, which that's my opinion what should have happened, or it was done during the application, which in my opinion is a shady practice and probably questionable as to whether or not we should have approved that. But
Wouldn't the intent be the same either way?
the intent would be the same either way, is to
I
avoid
think
having
we
to
should
go to the
find a way to
wetland
stop
agency
that.
with my application for a subdivision, because I conveyed the wetlands off the property. So, again, nothing would stop a developer or a person from doing that and conveying the land to a nonprofit like the Land Trust, whether it's, again, that land trust has to be willing to take it at some level. Why they would just take slivers of land or portions of wetland, or just pockets of wetland as compared to acres, right? There's a big difference between owning a large swamp that's protected as open space versus just a pocket of wetland.
What if somebody, if wetlands is conveyed, we can just make them go before the Inland Wetland Commission anyway. So if any wetlands is conveyed, you still need to go in front of the commission.
Statutorily, I
Or
don't
maybe
think
we
we
need
can.
to up a minimum, or,
Well, because the statutes basically dictate which subdivisions go before wetlands, right? They're gonna, if you have regulated activities, or wetlands on the property, the application has to go before them. The wetland agency then can consider all the activities that are occurring that are made inevitable by that application. We learned that in Twin Valley. Which means the houses that are outside the regulated area can be considered, because it's made inevitable by building the road. You see what I'm saying? So that came out of that. So even though, and then the wetland agency also has their ability to extend their jurisdiction beyond their upland review area if they determine there's a likelihood of an adverse impact to the wetland or water resource. So similarly, I would say, yeah, conveying out the wetlands in the subdivisions that we have approved where that occurred, that developer, that homeowner, or whoever's gonna own that lot, they have to come before the wetland agency with their next application for the house. They need a permit for that, because that's a regulated activity occurring in the upland, which maybe their hope is that, well, maybe the administrative agent can issue that, and I don't have to go before the commission, because it's just a single-family house. I think the theory goes is the whole subdivision would go before the wetland agency, they'd understand, yep, approve it, and then the individual permits would be issued by myself as the agent, because it was already approved as a subdivision. The wetland agency already looked at it, so here I am doing, I'm looking at it after the fact, and ensuring that the house construction won't adversely impact the wetland. Whereas that single-family lot, that one house, that threshold of disturbance isn't necessarily warrant coming before the wetland agency. I mean, again, I have the discretion to kick it back to the wetland agency for review. And the wetland agency can overturn my decision, so there's that option too. But I've yet to see that happen, and I don't know anybody who's challenged my decision to the wetland agency, so. But, yeah, I'd like to be able to resolve that, conveying, the carving out of wetlands to try to avoid a commission.
Is that going on? I mean, just bluntly, if that's their intent?
I don't know if that, I can't speak to intent, but I can tell you what happened. I can tell you the facts as it relates to the Upper Walnut Hill Holmes Road subdivision on the corner there, those 5 lots. It's exactly what happened, during the application, no less, those wetlands were conveyed out to the East Lyme Land Trust.
Who's in charge of the land trust? East Lyme Land Trust?
Right now, I believe the chairman is Art Carlson, and I'm unable to identify the other members. I haven't had an opportunity to dig deep into that.
Do they have any regulation or oversight?
They have a very little online presence. What the oversight, I believe the state attorney general oversees land trusts and those nonprofit agencies. They're kind of like the overseers, making sure they're following the rules and laws, I think.
Just to some degree.
Seems a little in the shadows to me. Maybe
I
by
think
design?
that was, I think, the message that the Lake Patagonia, the Patagonia Lake Association was trying to convey, is that
So, is it a private, the land trust, is it private, is it public?
Well, it's the East Lyme Land Trust, Inc. They identified that the business address, the mailing address, is in Glastonbury, not even in town. So while the chair is Mr. Carlson, I don't know the other members, so I'm not sure how.
So it's a private company?
It's a private nonprofit,
A private nonprofit?
401c3, yes.
I'd like to see a little more transparency with that company. But
Yeah.
it does say in 7-2-3 that there can't be more than 50% wetlands on conveyed open space. So there is that. They can't do 100% wetlands,
Right.
but
Now, that says no more than 50%. So one of the things that, again, that came up in the Twin Valley application is in that particular, the open space contained more than 50%. But it met the 50% upland to wetland. They just wanted to give us more wetlands. So in one case, they met the minimum, and then it's like, okay, here's the excess land, you can just have it. So I don't know if and that's how that got interpreted in that application. But I wonder if that's limiting. And one thought that I had is that if wetlands, in the opinion of the state, is so important that they pass legislation, right, to have in the wetland agencies oversee the activities that occur in and within, in proximity to them, maybe it makes sense to say, you know what, maybe the town and the government agencies should be acquiring the wetlands to ensure that their future preservation.
Is there a cost to the town though, to maintain or?
I mean, there is a cost to the town to maintain open space, whether it's wetlands or not. I mean, you're gonna either have to contend with some wildlife, beaver dams, down trees. If you're using it for hiking, passive recreation, you gotta maintain the property in that regard. Is the cost of services significantly less than a single-family house? Absolutely. When you're not generating any school children.
And you're saying it may be worth the minimal cost?
I believe it is. If we own the open space, absolutely. It's worth the cost.
because the cost is nominal as compared to what it would cost if it was developed. When you look at the cost of services. There's a number of studies that have been done by the Connecticut Farm Bureau, so I will say that is a little biased, but nonetheless, they've demonstrated how the cost of services done open space is significantly more profitable for a municipality.
I may recommend to anyone, because I know I'm going on Saturday at Wesleyan, they are hosting a conference on land conservation. Just seems very timely for what we're doing right now.
I mean, not to drag this out, but I mean, should there be some language in there to maybe request that if there is wetlands in the open space, that we recommend it go to the town rather than a private entity? I mean, I don't want to add more to this, but it seems like, I mean, if what happened, was it Darrow's, you said, where they went over 50, or
That was Twin Valley.
Twin Valley? I mean, if stuff like that is happening, it probably should be at least maybe a little wording in there to maybe stop that from happening.
Yeah, well, in the Twin Valley case, that open space did go to the town.
Okay.
So we, in that particular, that was something, I do remember during the application, though, I believe the applicant had said they were considering the land trust. And then I think just before the approval or after the approval, they shifted gears and said, does the town want it? And I believe I indicated that the town would be interested in it. And then we since acquired it. So that's worked out in that particular case.
Yeah.
And we got, the 70 acres preserved, so out of a 90-acre piece. So all right, I'm good if there's anything else.
Yeah, I think I'm
Do we
good.
have any other questions? All right, do we have any motion to adjourn?
Motion to adjourn?
Second?
All right, do we vote? All right, all those in favor? Aye. All right. We're adjourned.